All right. Hello, everybody, and welcome to our lunch bunch. We have a special guest, Thomas Humann. He is a lawyer and he is an advisory board member for the Firefighters Burn Institute, and we are very lucky to have him come on and speak with us. So thank you very much for coming.
Thank you, Lauren, and it's good to be here with you. It's great to be part of the advisory board now. And by way of introduction, as Lauren mentioned, I am Thomas Humann. I'm a practicing attorney, specifically a civil litigator here at Boutan Jones Incorporated in Sacramento, California. By way of a little bit of background, I did spend 24 years prior to the practice of law as a helicopter pilot and fixed wing pilot, split halfway between 12 years in the Marine Corps and 12 years with CAL FIRE. So I've had quite a bit of experience dealing with traumatic events, and in some cases, burn events, where I've had my fire crew actually get burned over and saved by the wonderful people at UC Davis Burn Center, which is actually what inspired me to give back and try and do some help and some work for the Firefighters Burn Institute. So with that, as I mentioned, I am currently a practicing civil litigator here in Sacramento, and I specifically deal with contract issues, real property, business disputes, probate in the states, and a variety of other civil litigation, sometimes touching on other issues like employment. Some of the areas that I have some knowledge of, but don't practice on a daily basis, would be other civil areas dealing with personal injury. And one thing I do not touch is the area of criminal law. All that being said, I would throw myself out there as a service to folks that are survivors and want to be put in touch with someone. I happen to know a lot of people in the Sacramento area that would be great resources for any type of legal issue or legal problem or legal question that you might have. And so I'll make sure that Lauren has my contact information so that you can reach out at any time with any of those questions, whether or not they fall into my area or not. So that being said, we talked a little bit about the fact that I deal with contract work and with some other business disputes. And I wanted to chat just a little bit to try and give everybody an overview of some things just very generally to consider with regard to, hey, I've been wronged about something and I want to take some sort of legal action. What do I do? What do I have to think about? I'd say generally in the civil world, you've got a couple of initial things to consider. And the biggest one when you're reaching out to an attorney in your head, and you're right about this, is going to be how much it's going to cost me. Big question is always going to be money. Us lawyers are very expensive. So I would divide that probably into two buckets. One is you have a bucket where you're going to be paying, let's say, by an hourly rate or maybe a flat fee, but probably an hourly rate. And then you've got another bucket where that legal action is going to be on a contingency fee basis. And all that means is that you're not fronting the money. The law firm is fronting the money because they think you've got a good case. And the agreement that you signed with the law firm is going to be such that the law firm takes a cut out of the award or settlement that you get on the backside. And that can be in upwards of 30 or 40%. So all these things are things to consider. What exists in that first bucket are going to be contractual issues, employment related issues, business disputes, family and estate planning questions. On the other side is going to be your personal injury, medical malpractice. There's probably some other ones that fit into those two buckets, but it's always a very important question to ask up on the front side. Other things to generally consider, let's say you've got, because everybody signs contracts for stuff, whether you have somebody working on your house, you're buying a house, you're selling a house, you're buying a car, whatever it happens to be. But then something goes wrong. The car doesn't work, the house is messed up, the contractor no-showed, whatever the case may be. And so now you've got a contract dispute, or maybe it's the other way around. Maybe you didn't pay the full bill for a contractor because you think they screwed up, but now they're suing you. So it could go in either direction, but there's an important couple of things that I want you to look for, maybe even before you reach out to an attorney, just something for your own personal knowledge, is take a look at that contract. And in that contract, there's going to be a couple of things. There will probably be some sort of provision in there dealing with dispute resolution. And that could have a couple of important things in it. It could say that you have to go to arbitration. And if it says that you have to go to arbitration, you've agreed to it by signing the contract, and you can't sue them in regular civil court down here in Sacramento County. Another is going to be what's called an attorney's fee provision. And that one's really important for you to take a look at as well, because it could say in there that the prevailing party or the winning party in any lawsuit gets all the attorney's fees paid for by the other party. And that can be a six-figure plus amount of money. So you're going to want to look for that before you actually start thinking, well, I'm going to sue this guy, he did me wrong, and make sure that you've got like a really solid case before you go and you front $150,000, lose the case. And now not only did you lose the case, but now you got to pay their attorney's fees. But it can be a huge windfall for you as well. So there's some gambling involved, there's some gauging involved, there's just a lot of like calculation. But those are a couple things that I want you to look at if you've got any sort of contract, is look for those provisions in there. I'm going to go ahead and pause for just a second. I could keep talking all day, but I want to pause and see if we have any questions.
So my question would be, if, for instance, someone was in a contract that said that the winning party will pay all the attorney's fees, but maybe otherwise they've got a really good case or something like that, how likely is it that people will settle outside of court, or is settling, or the likelihood, I guess, of going to court versus settling, and how that'll impact fees?
Yeah, so the fees will accrue over time. So, you're starting out you've paid nothing. And then you can almost picture a graph where it's going to slowly ramp up, ramp up, ramp up. And if you end up going to trial, those fees they're going to really get high. Okay. And that this line that I just drew, that could take 2, 3, 4 year period of time. Civil litigation to actually get to a trial with a jury can take years. Also, another very important consideration if you're considering litigation. That said, far less than 10% of contract disputes, or any civil dispute for that matter, actually go all the way through a trial. 90+% of disputes settle. And that's a good thing. It's a good thing, for everybody except for the attorneys, which means that it's a good thing. We get plenty of work. I don't need to be going to trial all the time. I would much rather broker a settlement. So the typical path is like this, though. If two parties don't see eye to eye on something, the odds on an early settlement are slim to none, because people are kind of locked into their position, because otherwise they wouldn't be suing each other. What the place where you can get a settlement can happen in like one of two places, really. One is after you've started to kind of fight it out, there's this period known as discovery, where you're asking each other a bunch of written questions and you get the opportunity to conduct depositions of each other's sides. When you get through part of that process, the nature of the claims start to crystallize. There's evidence now, and the parties can see maybe a little bit better. Oh, okay, well, maybe I only really can get this much money, or maybe I only really owe this much money. It starts to take some form, or they start to realize, oh crap, I don't know if we're going to be able to win this case. So there is a phase there during that discovery where it might be opportune to reach out to the other side and say, hey, do you want to have a mediation here? You hire a mediator, you put forth your arguments, the mediator bounces back and forth between the two, and you try to hash out a solution. It's very much a numbers game at this point. There's a little bit of legal argument, but really it's more just about the number. You go high, they go low, and you try to, meet somewhere in the middle. And all the while, a good attorney is telling their individual parties like, hey, realize if you do this now, you could end up saving another $100,000 by not continuing forward. So kind of factor that into your settlement to try to facilitate your side to play ball. Unfortunately, if that doesn't work, what ends up happening is the litigation continues. You may have some motions in court before you get to trial. And the fees now have started to climb up to such a point that with that prevailing party provision that we mentioned earlier, that becomes the tail that starts to wag the dog, because it becomes more valuable than the actual lawsuit. And so now the parties are like, I can't settle now because I can't, I'm into this for over $100,000 in attorney's fees on a $50,000 or $75,000 case. So they can't back out at that point. And that's unfortunate, which is why we try to facilitate settlement a little bit earlier. So you got to think about that before you get to the point where you're essentially fighting a lawsuit over attorney's fees.
Kind of to piggyback on that same question, you had mentioned that you can either have the attorney or the office, I guess, take like a percent or pay the attorney. I guess kind of two questions. One is, would the attorney tell you which one would be better, or is that something that you need to know on your own? And then also, is there, like, would you suggest one way or the other? Or is it just depend on what you're actually filing for?
It usually depends on what you're filing for. Different firms have kind of, I don't want to say set in stone, but different policies as to how they do it. So like my firm, 99% of the time is just hourly. We don't delve into a contingency fee. There might be an exception if let's say the case is a slam dunk case. Client may not have a lot of money, but they could win a lot of money. Might be able to broker some sort of deal with the client to help them out and say, hey, we'll take a percentage of the winnings so that you don't have to come out of pocket. So firms have their own ways of doing it. The general rule, like I said, is that you have certain types of lawsuits or certain types of claims that generally fit into that contingency fee. And they are really the personal injury type cases, medical malpractice, which is really just a subset of personal injury. And the reason for that is kind of what I just explained. It's really that the amount that could be won in either of those, whether it's a serious car accident or a surgery gone completely wrong due to negligence, the amount of money that you can win on that is very high. And generally speaking, you're talking about an individual person, not some company that got injured. Therefore, 9 times out of 10, they don't have the money to bankroll that litigation, because that type of litigation, especially if you're talking about maybe a med mal case, with the amount of expertise required and expert witnesses that you're going to have to bring in, it's going to, when I say 6-figure, we're talking well over 6 figures as far as funding that litigation. So it starts to get to a point where the individual person wouldn't be able to afford it, and there would be no business, business model wise, it wouldn't work. There would be no lawsuits for people that got injured if they didn't do it on a contingency fee basis. A similar type of lawsuit, which is a little bit beyond scope of like a conversation that would probably be applicable to our audience, would be like a class action lawsuit, though. those are always a contingency fee as well. So there's a product that's out there that's generally bad. This could fall into the medical realm, and quite often does. So take the opiate cases that are big news these days. Those are all going to be like a class action type of suit where the law firms, actually a bunch of law firms, will join together. They'll cast a super wide net. You probably get the letters at home before. Have you ever had this happen? Have you ever had that happen? Sign on. They try to get as many people as possible. They'll go out and they'll try to get in upwards. Sometimes they get hundreds of millions of dollars in a victory against some giant pharma company. But then the law firm gets their 40% of that and then divides the rest over the, million some odd victims. And they walk with a few dollars.
So since sorry,
No,
finish that thought.
There's a lot of math and a lot of calculation involved. The easiest answer for Lauren's question, though, is really it's probably going to be predetermined. There might be a little bit of wiggle room, like I said, in a very extenuating circumstance, but generally it's going to be driven by the type of case that you have, whether or not you're paying a flat fee or an hourly fee versus a contingency fee. The flat fee, hourly fee, that probably is something you could try to negotiate with a law firm, the difference between those. If you were capped out and you're like, well, I've only got a max of $50,000 that I'm going to dump into this. Will you take this case or not? You might get a law firm, a small law firm, probably to bite off on that. I can tell you, as straight up, my firm wouldn't do that.
So to give us kind of a reality check in just a few minutes worth, I know some people would think, okay, but there's pro bono legal advice. How rare or common is that? And what's how would people go about finding pro bono legal advice?
You know what? I can push some resources maybe offline after this to Lauren. I'll pull some links for that. It's not out of the question. Typically, pro bono, for an attorney to represent somebody pro bono, there does need to be some sort of proof that there's a legitimate need there, right? Financially speaking. So, for instance, I can't just represent my family in a lawsuit, and want to compliment and just call it pro bono work. I could represent them on the side, but as far as it being officially pro bono work, there actually needs to be like a real financial need there for it. So I'll just throw that out there as kind of a general thing, that if you got somebody that fits into that category and they really are strapped for whatever reason, then yes, they should certainly attempt to avail themselves of pro bono, because I'll tell you what, you can get some really, really top-notch attorneys. It may not be directly in what they practice every day. So that might be the catch on it. But some of the very biggest law firms in the country and the world really push their attorneys to get 50 or 100 hours per year of pro bono work. And those are incredibly talented attorneys. The reason, well, they're doing it because their firm wants them to, but they're also doing it to get actual courtroom experience. Because if you're at a gigantic law firm as an associate attorney, you may be buried in paperwork all day long in your office, and you're like, man, I want to get in front of the judge and I want to argue some stuff. I've got the talent for it. I've got the skills for it. This is their opportunity to do it. And they feel like they're really helping somebody out, as opposed to, helping Apple out or Google out, which isn't quite as rewarding.
Cool, thanks. And I think we'll do one more kind of overview-y question from Lauren.
Do you mind just giving us like a quick estate overview? I know you'd mentioned that that's something you do as well.
Yeah, so to be 100% clear, we have a pretty robust estate planning group at my firm at Boutin Jones. My role is when things go haywire. So I'm in the litigation section of my firm. So I only really get involved when the system breaks down. Best way for the system not to break down and not to have a problem is to get a good estate plan on the front side rather than just handwriting your will. So that said, yes, and this would fit into that bucket of, this one might actually fit into like a flat fee type of arrangement. Like I said, maybe not with my firm in particular, but there are plenty of smaller individual, sole proprietors or small law firms in the Sacramento, greater Sacramento area that for a flat fee will help you generate an estate plan. And by estate plan, really, I'm just talking about wills and trusts. You can have both. They should work in conjunction with each other. So everybody's pretty familiar with how a will works. You name somebody to take care of all the things when you pass away, and then you can list off all the things that you want different people to have. It's usually done via percentages, because the things that you actually own may change over time. Before we even get to the writing of a will, though, I should probably throw out that most things, if you work your arrangements properly, won't even be affected by the will, and it will not require any sort of probate. And probate meaning that it has to go into the court and have the court look at the will, talk to the executor of the will, and say, yes, you will carry this out. A lot of people will try to avoid a lot of that, mainly because it's just slow and it can cost money to have to go to court. So what do you do in lieu of that? Well, you've got all of your bank accounts, your insurance policies, your property, all of those things. If what you should do is have named beneficiaries tied to each one of those. You probably have it on like your 401k. By doing that, you completely avoid probate and you don't have to go to court. And really, the will essentially just serves as like a catch-all for maybe all the small things that you haven't already allocated, so that whoever's in charge when you pass away doesn't have to wait for the court. They don't need to get blessing from anybody. They can simply go direct to the document, whether it's your insurance policy or the deed to your house, and say, all right, this goes to Emily and this goes to Brad, and they can just make things happen. And that's a big time saver. It's a money saver. So to the maximum extent possible, I would highly recommend having those named beneficiaries on all these other documents so that you're not wasting time and money elsewhere. That said, it's still good to have a will for the catch-all, because you're going to have other things that, your family heirlooms aren't going to have documents associated with them that are deeds or named beneficiaries. Another way that many people utilize a document to keep things from having to get bogged down in court is something referred to as a pour over will. And all that says is all of my stuff when I pass away that's not allocated elsewhere before pours over into this trust. And now, so all of a sudden, all that stuff gets poured over into this trust that you've written based at the same day that you did the will. And now somebody is named as the trustee, one of your kids, or if you don't trust any of your kids, a third party. I say that because we have kids fight all the time when they're adults, and that's when I get involved. Or some sort of third party as the trustee. And now they can just manage that as trustee, and you've totally avoided probate. So sitting down with an estate planner to structure something like that. And by the way, those trusts can get extremely detailed and complicated for anybody that's either a high earner or has a lot of other assets or has a complicated family dynamic. Like I need to sit down and update all mine, because I've got, kids from different people, and you want to make sure all that stuff is covered to try to prevent a problem down the road. And so you can have these very complex trusts that then divide down into different trusts. I'll just give you a very basic example. You can have a trust that then has a trust A and a trust B in it. And the trust A would be for whoever the surviving spouse was. So mom and dad are alive, dad passes away, mom survives. She now has everything that was in trust A. That's hers. It's hers for the rest of her life. But because the parents agreed while they were both still alive that they wanted to ensure that something got left to the kids and the grandkids, they created this trust B. And so as soon as dad died, some property got put into that trust B. It's now irrevocable. Mom can't go and, go blasting around with her new man over to Europe and stuff like that and blow all of the money that they made, because now she can't touch it. And that gets earmarked for the kids. So there's different ways to arrange that stuff. And it's pretty smart once you get a bigger family to go ahead and sit down with somebody and have them kind of walk you through some of those considerations. And there's a whole other world dealing with the tax considerations and the ways that you can move stuff around in order to shelter things from the tax man as well.
Clearly, we need to have a longer discussion on this because there is so much, and that's why you get to do a lot of years of law school, right? But thank you so much. This was already a really helpful conversation.
You're very welcome. Thanks for having me.
Yeah, thank you so much.
So folks out there watching, if you have any other questions for Thomas or just legal questions in general, feel free to email Lauren or I. I'm VALORIE at ffburn.org. So thanks.